exciting and interesting exploration of the evolving landscape of arbitration law. At the outset, I express our heartfelt gratitude for your presence today. Your commitment to advancing the field of arbitration is commendable, and your participation is integral to the success of this conference. For those of you who may be joining us for the first time today, me to is the sincere aim of fostering meaningful dialogue, scholarly exchange. That conference serves as a platform for leading minds in the field to come together and share insights and address the pressing issues facing arbitration law today. We are driven by a shared commitment to excellence, integrity, and innovation in the study of arbitration law. This is the fifth such edition to be organized, and we trust that this will be just as successful at promoting a scholarly exchange of ideas as our predecessors. Today, we have the distinct pleasure of inviting an expert panel to delve into two particularly pertinent issues facing arbitration law today. The discussion on the first issue will explore the effects of insolvency proceedings on the scope, rationale, material of arbitration agreements, while the deliberation on the second issue will concern the role of arbitral institutions in facilitating cross-border insolvency with a focus on reconciliation arbitration. Joining us on the panel are distinguished leaders and practitioners in the field of international arbitration law. First, we are extremely honored to have Professor Shala Ali, who is a professor of law and associate dean at the University of Hong Kong Faculty of Law and a director of the LLM program in the arbitration and dispute resolution section. She's been engaged in dispute resolution reform at the regional and global levels, including the USAID, IFC, World Bank, and the United Nations. Extremely happy to have Professor Gary Bell, who's the Secretary General of the International Academy of Comparative Law and an associate professor at the Faculty of Law of the National University of Singapore. He also practices as an arbitrator based in Singapore, but also sits on tribunals throughout Asia and beyond. He was the founding director of the LLM in International Arbitration and Dispute Resolution at the NUS. We are very honored to have you alongside us here, sir. Then we are joined by Mr. Ajay Rao, the founding partner at ANR Law LLP, and is an experienced arbitrator with extensive experience in corporate transactions and commercial litigation. He's empaneled with the India International Arbitration Center, Asian International Arbitration Center, Kuala Lumpur, Brazilian Center for Mediation and Arbitration as an arbitrator, and is also a member of several arbitration institutions across the world, a member of the advisory board, as well as on the peer review board of several academic journals. Thank you for joining us, sir. We are next joined by Ms. Varuna Bhandrale, who is a partner at Trilegal with an extensive experience with dispute resolution spanning diverse types of corporate transactions. We're very happy to have you here with us now. Ms. Chitra is a partner at Trilegal with extensive experience in complex commercial litigation, insolvency, as well as arbitration. She regularly advises multinational companies before state and central investigative authorities. Thank you for taking time off, ma'am. And last but not the least, moderating the panel are our distinguished professors, Mr. Hari Shankar and Ms. Sahana Ramesh. Thank you for your time, professors. Together, their wealth of knowledge and experience promises to shed light on this complex and timely topic. Without further ado, I request our scholarly panelists to set the ball rolling on the conference. Thank you.
Thank you, Anirudh. Thank you for the generous introduction. And as Anirudh mentioned, for this panel, we have two broad topics. One on generally on the interplay between two regimes, arbitration and insolvency, and we also look at issues related to cross-border insolvency. To start the discussion, let's invite Dr. Shala Ali to give a general remarks on the arbitrability of insolvency disputes, particularly looking at the US and Hong Kong.
Thank you so much. Can you all hear me okay? Yeah? Well, it's wonderful to be here and to see all of you, and I can tell that you've been working hard, and it's a topic of interest because you're working on a moot problem, right, that is related to this theme. So I was asked to give a little background about how the US and also Hong Kong manage these issues, this interrelationship between insolvency and arbitration. And they're quite similar. I think some of the issues and policy considerations are not that different. Within the US, it's governed by the Federal Arbitration Act, which is generally a pro-arbitration, pro-enforcement act. Though it's quite old and dated and has not taken up the unsubtravel model law. There's a whole other topic for discussion. But in general, it aims to help facilitate the enforcement of arbitral agreements. But also sitting alongside that, there are the US Bankruptcy Code, which exists within the federal law. And so here there is the issue where within the US, there can be an automatic stay. When you have a bankruptcy petition that is lodged, this automatically halts all judicial proceedings and administrative proceedings against the debtor. And so generally the courts have held that this doesn't automatically preclude arbitration in the US. It's something that the courts have to determine whether, again, this question is the bankruptcy the core of the arbitration, or is it a peripheral issue? And again, if it's a non-core issue that is arising out of the arbitration, say it's a contract dispute, many jurisdictions will allow this arbitration proceeding to continue. However, if it is core to the dispute, then this automatic stay may hamper the ability for this arbitration to continue. And it's similar in Hong Kong. It's not that different. We have in Hong Kong unsubtravel model law, which is embedded within the Hong Kong Arbitration Ordinance. So here, again, it's very much a pro-arbitration enforcement regime. There is a great desire to give effect to arbitration agreements. Alongside this, though, we have statutory limitations that involve bankruptcy. So, for example, if you have a petition for a winding up of a company or appointment of liquidators, these are within the exclusive jurisdiction of the courts. And so then this will also be issues that are not arbitrable. So again, here instead of the core, non-core distinction that's used in the US, here the terminology used is ancillary and non-ancillary. And again, it's a similar kind of analysis. Is the bankruptcy or liquidation the core components of the analysis of the arbitration? If so, this may be affected by these statutory limitations in Hong Kong for winding up and also for appointment of liquidators. So there is similar kind of analysis in both. They have different terms for the laws and the statutes that are relevant, but the role of the courts, again, is quite similar. The courts have been empowered in both jurisdictions to make those determinations. And so that's where the authority sits in terms of deciding whether this arbitration can proceed or not. So I'll leave it at that. Thank you.
Thank you, Shala, for that very brief introductory remarks on the interplay. So now let me come to Varuna to look at this interface between insolvency and arbitration from an Indian context. Varuna, your thoughts.
Thank you so much, Dr. Hari, and hello everyone. Very pleased to be here sharing our thoughts on all of these issues, and we hope that there will be enough dialogue between us for us to be able to explore this very interesting topic. I'm hoping that all of you guys can hear me. Hopefully I'm loud enough. Now, like Shala mentioned, that there is a lot of synchronization in a lot of jurisdictions on policy considerations of how do you go about an insolvency process. Like she mentioned, US and UK follow something of a core, non-core process where non-core items can be arbitrated. India also, I would say, does not have a distinction on core, non-core, but somewhat slightly different. They look at whether a corporate debtor will be adversely affected by continuation of an arbitration. Now, a lot of you may already know that India also has a similar regime where as soon as the company goes into corporate insolvency resolution process, there is a moratorium on all litigation that's ongoing. Now, case laws have come about which have said that if there is a litigation or an arbitration that is for the benefit of the corporate debtor, let's say the corporate debtor is going to get some money if they have a favorable award, or if they are undergoing some challenge to an award proceedings, which could be favorable for the corporate debtor monetarily, then those are allowed to continue. Everything else is stopped and stayed. The rationale for that being that while the company is undergoing insolvency resolution process, there is some sort of a status quo maintained so that all stakeholders' interests can be taken care of. Now, the question arises, and I think that's the very interesting topic that we're covering today, is can insolvency-related disputes be arbitrated to a greater degree? Can you, instead of, say, having an IBC, can you have complete arbitration for a company which is probably not performing very well and needs to undergo insolvency restructuring process? Now, the answer to that is twofold. The first answer is that there is already enshrined in the IBC a provision which says that for all cases which fall under the Insolvency and Bankruptcy Code, no other statute applies and no other dispute mechanism can be used. So it becomes very clear that yes, you have a company that needs to undergo insolvency resolution process. The only place you can come to is the IBC. You cannot go under the Arbitration and Conciliation Act or any other kind of dispute resolution mechanism for that matter. So the current position in India is insolvency is only under the code and nowhere else. The second aspect to this, and that I think is the underlying basis for why this embargo has been put in place, which has been expounded further by the Vidya Drolia case of the Supreme Court, where the court has basically once again enunciated the fact that where you have disputes which have interests in rem or the interests of the public at large, then those disputes cannot be determined by arbitration. They have to necessarily go to the courts. And in this case, the court specified is the National Company Law Tribunal under the Insolvency and Bankruptcy Code. So that's how we come about the fact that this is not going to be arbitrable. Now, I think the one thing, and I'm hoping that we'll explore this during the course of the panel discussion, is going to be, can we do something in India? Is there a case for making part of or the whole of insolvency disputes arbitrable? I think I mean, I'm sure that this is something we're going to explore, so I'm not going to detail it at the moment. We'll take it through as questions keep coming in. The idea would be to look at the advantages and disadvantages. So, for instance, arbitration will ensure that you have a more global outreach, probably better enforcement. But on the other hand, you're also looking at issues of, too much confidentiality. How do you manage this, the stakes of various stakeholders who may not have all signed an arbitration agreement and are, let's say, third-party creditors or other entities who are concerned with the company? So how do you balance those interests? Can they even be balanced? I think that's something that we need to explore from an Indian perspective today. So back to you, Dr.
Well, now may I request my colleague, Professor Sahana Ramesh to look at the next issue, asking the other panelists to give their general introductory remarks.
Thanks, Hari. So as we move to transitioning from looking at domestic insolvency proceedings and their interplay with arbitration, perhaps we could move on to looking at how cross-border insolvency proceedings may be affected or may impact international arbitration proceedings. So may I call upon Professor Ben to start off the remarks?
Thank you very much. I'm very pleased to be back at the National Law School. I've been here many times in the past. I thank the Law School for the invitation and Trilegal as well. Let me, before I go and talk about whether it's likely and good idea to actually have arbitration decide core issues of bankruptcy. Let me go back a little bit about core issues. Singapore is no different from Hong Kong or in terms of defining core issues. If you want to check it, it's a famous case in Singapore, not famous elsewhere, but in Singapore, Lawson oil case is a good example of that. So there's not much of a difference. I just want to say, however, that one of the assumptions is that what would be a core issue in arbitration is the rescheduling of liabilities. So in the common law, you don't really do that. We don't do that, right? Contract is a subcontract, and you either liable damages, and these are the damages you owe. In civil law jurisdiction, in many civil law jurisdictions, an increasing number of civil law jurisdictions, the judge in deciding a purely contractual issue if there's a change of circumstance, and usually when there's a bankruptcy, there's been a change of circumstance or something, can actually rewrite the contract, actually. Can basically look at the circumstances and in fairness to the parties. And so, for example, in Germany, it started a long time ago through their case law, what we call jurisprudence. And recently, a place like France, who was very much against that, had a similar position to English law, that a contract is a contract is a contract, recently changed our code. And now, if there's a change of circumstance, the risk of which was not assumed by the parties, then the parties can enter a negotiation, and if they don't have an agreement, the court can reduce the obligation or even cancel it, even retroactively. So it goes even further, because in doing that, they might look at all of their debts, which is kind of the stuff that a law court would do in bankruptcy. We have another example in the United States, a UCC, which specifically with respect to sale of goods, so it only applies to sale of goods, says that if there's I'll call it change of circumstances, if called differently, but what happens is that the seller can decide to give less than he was supposed to give under the contract, but has to prove to the court that he's treating this basically creditor fairly compared to the other creditors. So how is that different from the process? So in defining what is a core issue, if the rescheduling of liability is one of the core issues in civil law, this can be done by contract. So maybe we can look at that as one example where the civil law allows similar process in its arbitration all courts, similar to bankruptcy. Maybe that's one way of looking at how it can evolve. That being said, I want to move to the next issue. Would it be a good idea to give bankruptcy proceedings to arbitration rather than the court? I'm not saying it wouldn't be a good idea, but I don't see how it would work. I understand the desire to go to arbitration because there are quite a few advantages to go to arbitration. It is often faster. It also enforceable more easily internationally. So I understand that. But it doesn't get rid of if even one country would allow that, how do you get rid of the problem of arbitrability in other jurisdictions? Right? Even if India would say, okay, this becomes arbitrable, when you try to enforce it abroad, they will use their own definition of arbitrability, which will make it very, very difficult. Already raised was the issue of consent. Again, the beauty of an arbitration proceeding is that you've got to come. If you don't come, you'll be bound by it anyway, right? So you're presumed to be a participant. I don't think you can call it consent, but you have to come. In arbitration, you can't do that. Now, that being said, there are other forms of arbitration other than commercial arbitration. There are ways of doing legally mandated arbitration. We have that in labor law. Maybe this could be conceived in arbitration, but be mindful, if you want this to work internationally, you have to change either the New York Convention, you have to change the way, or have a specific agreement on bankruptcy. And I frankly think this is unlikely in my life. But that being said, personally, I'm not an expert on bankruptcy. I should say that. I do understand that the relationship in bankruptcy. But personally, I think with all its flaws, the UNCITRAL model law on cross-border insolvency is probably a better way, even though it's a limited solution. It allows, nonetheless, a recognition of decision, a collaboration between the courts. I think, at least for now, it would be a better spent time on promoting that than promoting a new way of considering international bankruptcy. Now, I think if the country wants to do it to force arbitration locally, then
May I invite Ajay to next slide?
Hi. I have actually very different thoughts on what Gary just said. Let's talk about two things. A, do we need arbitration in insolvency? And that's the first question we need to ask. If we do, why do we need it? And the only answer can be the New York Convention. Because other than that, why would you want arbitration? It's just easier enforcement if you go it via the arbitration route. The second, I think, and this is where we need to slightly bifurcate the debate to my mind is, do we want the insolvency process through arbitration? Or are we saying that insolvency should give way to arbitration or arbitration should give way to insolvency? I think those are entirely two different debates, right? Because if you think of arbitration, insolvency and arbitration are two parallels. They're actually contrary to each other because insolvency is legislation oriented and arbitration is autonomy oriented. And the East and West shall never meet, right? How do you say that something which is inherently this, let's say, a sovereign domain of making sure creditors are paid, making sure transactions are avoided, making sure the administrator takes over estates, how do you give it to a private system of adjudication, right? The flip side is, if you don't do that, is it easier for the debtor or the creditor to go down the insolvency road and frustrate somebody's claim, or go to arbitration and not face the arbitration and invoke insolvency and frustrate the claim? So let's take 3 steps back. When you're talking about insolvency, whose perspective are we talking about? Are we talking about the debtor's perspective or the creditor's perspective? And if you see insolvency, it's all creditors' perspective, right? Now, from that starting point, let's move backwards. I, as the creditor, want to sue Volkswagen, right? Then comes the question of, are there Volkswagen subsidiaries or Volkswagen, the German entity? It has assets everywhere. I invoke Volkswagen insolvency in India. I'm sure that there are arbitration agreements in place. What is the first thing Volkswagen is going to do? Volkswagen is going to say, honor the arbitration agreements. Then the court in India is going to say, you are now on my turf. Public policy exception, I am the queen, right? Then comes the issue of comity. Now, this is what happened in Photochrome in the US decision. The US court said, don't go ahead with the arbitration, which is what? Which is an anti-suit injunction. If you remove the insolvency out of it, it's simply an anti-suit injunction. The Tokyo tribunal said, no, we'll go ahead and do it anyway, right? You come back to the US and they say, well, I told you not to do it. I'm not enforcing your award. So when we talk about arbitration, is it possible? Yes, it is. Only if we give way to comity. We recognize comity, which is what I think Gary was referring to as doing a better job of recognizing comity. That if there is a foreign claim as well, the insolvency court of the home jurisdiction should recognize it. Right? I know a lot of times we tend to skip this sort of mundane provision in the Indian Arbitration Act. But if you actually see section 41 of the Indian Arbitration Act, I don't think anybody's ever seen that in their practice or if there are judgments on it. It actually recognizes insolvency in arbitration. But what it says is that the receiver should adopt the contract, right? And it actually recognizes arbitration agreements in face of it. But then the question is, it doesn't recognize extraterritoriality, right? Which is currently the problem in the IBC as well. You are not saying that these provisions extend extraterritorially unless there is a bilateral treaty, right? So when you bring down arbitration, what are you really saying? You're saying 10 people across the world have a debt that this debtor needs to pay. Who gets paid first? So instead of going into a conflict of law analysis as to who will get priority, let's do arbitration instead, right? Let's all come on a common platform. Let's discuss whether it's waterfall or pro rata or whatever, who will get paid and how. To my mind, the only way that can work is through a submission agreement, right? Because who do I have an arbitration agreement with? And if you see the Larsen Oil judgment in Singapore or the Toys R Us judgment in the US, what are we really saying? We're saying, look, these people want to litigate. Let them choose their governing law. Let them choose whether the debt which is invoking insolvency is subject to an arbitration agreement or not. If it is, then we will see whether it's a core issue or a non-core issue. Then we will proceed. So what happens if the debt itself is not subject to an arbitration agreement, but you have 10 creditors across the world? Right? The only common platform can be a submission agreement. Then you get into questions of seat, governing law, and it's at that point that I think, like Gary said, arbitration will fail again. Because as a creditor, I would want everything in my jurisdiction. I don't want, let's say, France deciding on it, and then you bringing the award to India and courts jumping up and down in public policy saying, well, the French can do it, but we won't. Right? That is why I think, just kind of cementing Gary's comment, if it has to work, to my mind, the only answer is a submission agreement. But like he said, I don't know if we'll see that day, because once there is a dispute, parties rarely agree on anything. See, as creditors, we have a common problem. Do we have a common interest? The answer is no. If there is an asset, I want 100% of it. Why should I give you 10%? Why should I take 10%? Why should I be that generous to another creditor and forego my claim? Right? So again, to just summarize what I'm saying is, arbitration can happen theoretically. Practically, for it to happen, you need a lot of consenting parties agreeing on common set of governing law and seat. And the only way to do that is to oust the domestic law. Now, as sovereign countries, would we really want it? Would we really allow our public policy in favor of arbitration? And the only sort of theoretical answer can be an example from the CISG, where you sign an overarching convention which allows you to derogate from domestic law for certain matters. And in that convention is the submission agreement, where if you are a signatory to that convention, you automatically will go to arbitration and not to a home court. I'll stop with that. Yeah.
As we reflect on larger policy issues that might be at stake, may I invite Chitra to give her introductory remarks as well.
Agree. We'll be talking a little more from the Indian perspective, and whether we, as having Indian legislation in place, we really require cross-border arbitration in place, right? All of you have done insolvency in law school. Everybody's done the course, right? So you guys know the basic structure, right? You have an admission order where a corporate debtor is admitted into insolvency. It could be a financial, it could be basis of financial debt, or it could be basis of operational debt, right? A moratorium kicks in, right? And while I'm discussing the overall structure of insolvency, we'll also discuss how arbitration really kicks in, what we've all been discussing in the different facets, right? So you have moratorium that kicks in, and moratorium essentially states that you cannot have cases against the corporate debtor under any circumstances, which means that even arbitrations cannot continue against the corporate debtor, right? That is the one that Varuna was talking about. That is different from the discussion we are having on insolvencies being subjected to cross-border arbitrations, right? So that's one type of arbitration in the insolvency context. Thereafter, you have resolution plans which are put forth before the committee of creditors. The committee of creditors, through a majority, approves the resolution plan. And if it disagrees with any of the resolution plans, the entire corporate debtor goes into liquidation. Right? When we're talking about arbitration in this larger context, we're talking about arbitration one, like we discussed in the moratorium context, which is not as important. The other two which are coming out from the conversation is, are you going to have this entire insolvency structure subjected to arbitration, right? Which is essentially an arbitrator deciding on admission, an arbitrator deciding on filing of avoidance applications, an arbitrator deciding on the final outcome
of what the committee of creditors decide. The other facet is that only the committee of creditors, right, or the creditors enter into an agreement to arbitrate their issues vis-a-vis the corporate debt, right? So these are the kinds of arbitrations that we foresee in the Indian arbitration, in the Indian insolvency context. Now, very clearly, I would, at least to my mind, for the non-creditor issue, if you have the entire insolvency gamut covered under arbitration, I think we have a problem, right? I don't think any sovereign nation would say that that the jurisdiction of a company's court, which is under the Companies Act, will be given to an arbitrator, right? An ad hoc arbitrator. I doubt that a sovereign nation would allow that, right? That's the one side of it. The other is that's one part of the sovereign nation. The other is that a lot of these institutions themselves have not been subjected to arbitration yet, right? You have financial institutions. Sorry, what I was trying to get at is, in the context of creditors, a lot of the creditors are Indian based in India, right? They are not foreign creditors. So most of them would not want to arbitrate their issue, but resolve on the regulatory framework within India. It's only when you have foreign creditors would you resort to cross-border arbitration, right? In the Indian context, you have foreign creditors mainly in the case of financial institutions. Now, financial institutions themselves are not subject to insolvency proceedings. As most of you know, only non-banking financial institutions are subjected to insolvency at this stage, right? And where the government is not even open to approaching financial institutions into insolvency, to say that they should be subjected to cross-border arbitrations is something that is, I think, far ahead, and there's a long way for us to go and achieve that. Because a non-core issue, to my mind, is also subjecting an institution like a financial institution to which would be against public policy and subjecting it to cross-border arbitration. Yeah.
Thank you everyone for the excellent introductory remarks on the larger problem. So at this stage, let me ask you if anyone from the audience, if you have any questions to the panelists. Couple of questions, yes, on the points that we discussed. Yes. Please, may I request you to please introduce yourself and talk to.
I'm afraid I can't discuss my name is Karan My question is that for this panel as a whole, the first question is, can you just step back and understand why is there a need for an arbitrability of the insolvency issue in the first? What is the status for that needs to be stated? And secondly, as Ms. Sandala spoke about the COC approving the release plan, once the payment mechanism, the repayment mechanism is approved, the scope of the COC adjudication is merely the approval or the disapproval of the resolution plan. What is the scope for discussion and adjudication in arbitration in such a plan?
I'm exactly on the same page, right? Because I can't understand that if you have the mechanism for a majority approval on repayment of debt, for me, I'm not able to fathom as to how you would involve arbitration in that process, because you have IBC in place, which says majority, it is a creditor regime model. It says that as long as there's 66% majority, the resolution plan will pass or it goes into liquidation. So for me, that's exactly where I am. I'm not able to understand why we would require cross-border insolvency in that kind of context. I would think that you would require it if there are creditors who are around in jurisdictions outside India, right? Because then for creditors who are outside India, they would want to understand how will I enforce an order that I get, right? To that extent, I understand why an outsider would want an arbitration mechanism, which is easier in a third neutral nation. For the same reason, you have contracts between a foreign party and an Indian party, where they say we're going to have a neutral regulator, right? I would think in that context they would want it, but I don't understand why would you want it in an Indian context.
Well, if I may, well, we would want it in an Indian context. I'm just trying to be the devil's advocate, because look what happened in Jet Airways, right? You had an order, the Dutch receiver said, recognize my claim, and we said, well, we won't recognize it. If this was arbitration, And see, ultimately what happened was that there was a committee that did come in 2018 which said that center of main interest, if it's in India, we're going to do XYZ. They came out with draft guidelines. Again, we need to separate two issues which often get mixed. One is insolvency and comity, which has got nothing to do with arbitration. And the second is arbitration and insolvency and enforcement, right? What ultimately happened in the appellate decision is that the Dutch receiver recognized that you are the center of main interest. The foreign creditor wants to know how you're going to handle my money. Can a nation, under the garb of sovereignty, deny foreign creditors their rightful dues? That's the larger question you are trying to answer. Because as a jurisdiction, am I pro-commerce, am I pro-arbitration are two separate things. But am I a destination which is going to recognize legitimate interest of foreign investors? And if at that point I just bring up my walls and say sovereign policy, public policy, I'm not going to allow foreign people to take anything from my debtor, are you really furthering commerce? Right? So in that sense, it's not only about enforcement, it's also about recognizing the rightful dues of people outside your jurisdiction. Just because that common debtor happens to be in your home jurisdiction doesn't mean you are entitled to protect only your home people. That way, arbitration serves as a better answer, because then everything is happening in a delocalized manner. I am not unilaterally applying my domestic law on a foreign entity. We are taking consensus, we are applying the most favorable governing law so that each of us gets paid. That's what's going to happen through arbitration. So to that extent, there is a need. But does that really work is a very separate question, right? There is a need, but can we answer or address that need fully well? Well, that's what I think everyone else will decide.
I think it's slightly different, I think, from where the question is coming, right? In that case, there's one debtor. So are you saying that we go, who has a bet, if you go by the debtor model, individual debtor model, it will never result in resolution of the corporate debtor, right? So the question is, are you going to go by majority view or are you going to go by debtor view? Because if you go by debtor view, a debtor will always have a creditor view. A creditor will always say my claim is good on law. Yeah. But that will not necessarily be in the interest of resolving the corporate debtor. So how do you resolve? Because in that situation, the reason it's that argument eventually fell apart is they said the Indian insolvency law prevails, right? Yeah. Because it's based on majority. If you go on individual views, the problem that you will face is that you will not be focusing on the corporate debtors revival, but you'll be focusing on the individual claim. So the question is, where do we draw the line? And that's something that I'm also a little unclear.
It's a line in the sand.
Yeah, just to add sort of a practical side of this. So, you know, we discussed also the issue that the claimants, the creditors have common interests in being paid, but separate interests in how they want to do this. But the separate interests, I would suggest one way or one creative thought, you know, just if we look at practicality of the debtor is now in a fragile situation. You imagine they defend themselves in 10 jurisdictions, the legal costs. What's that going to do with their ability to pay back the claimants? If you think long term, this is again a sustainability question. You think long term, perhaps the self-interest is in the interest of collaboration, because if you drain the debtors of all their funds by instituting parallel sort of conflicting litigations in multiple jurisdictions, nobody is going to end up with anything. So that's just another thought.
One of the examples, Ajao, you mentioned was that you have a debtor who's an Indian and creditors around the world. But the debtor who is Indian might have assets around the world, which adds another level of complexity, because even if we accept the court in India will render a decision, recognizing that court decision elsewhere to get to the assets, and the creditor in the country where the asset is might be in a better position to try to somehow put his hand on it, at least temporarily. There's this additional problem. It goes to committee, right? It goes to what Ancetral model was going to do, basically. We don't have a system yet for arbitration to do that. Maybe we can think out loud of how to do that. But the problem is coordinating the different aspects.
And I fully agree with Gary on that. I think one aspect, the creditors and where they're located is only one part of the issue. The other part of the issue is what is it that you're going to do with the assets. Now, currently, the way the Indian insolvency regime is, while we do have provisions in law which says that, hey, how are you going to act against foreign assets? You have to have government bilateral treaties, agreements, etc. None of that is actually in effect or in force at the moment. So what we're suffering with, and my personal take is, and like Gary said, I think what we're looking at is some place where everyone has a cohesive stance in it. That does not necessarily have to be arbitration. In arbitration, the law has advanced to a degree where it's more universal in how it's applied, how people take it, etc. But with efforts, probably we could reach the same thing with insolvency law, which is not the case at the moment. We're in really early nascent stages. But can you never achieve this? That's, to my mind, the answer is that it is going to be possible at some stage. Maybe it'll take a couple of decades or more or whatever, but we could reach that. Now, then the question becomes that only because arbitration at present has that universal appeal, does it make sense for a country to give up its authority over how a company established in its jurisdiction should be treated, revived, how the interest of stakeholders can be addressed? That, I think, is a question that until this gap is bridged between how insolvency applies globally and how arbitration applies globally vis-a-vis stakeholders and assets, what do you do? Do you need to do something? Do you need to transfer it over to arbitration? And to my mind, that's the question that we need to address.
Thank you. So picking on that last point, is a general question to all the panelists. So if you look at the others point, the competing interests that both these regimes are looking at. So from a normative or a legislative standpoint, the question of an arbitration law taking care of insolvency disputes, if at all a country is ready to do that, make a legislative change and allow arbitrations to happen in the insolvency context. So is it going to undermine or compromise the larger social and economic interests of the stakeholders? So what do you think is pushing the countries not to take that part of allowing arbitration to happen in insolvency context?
Yeah, I'll just jump the gun a little bit. I mean, I'm just being extremely optimistic here, not that I fully agree with this view, but you do take court assistance even in arbitration today, right? If you have to avoid transactions, if you have to do all of those core features of insolvency, what prevents an arbitral tribunal from requesting court assistance in that home jurisdiction, right? The question that I think we're trying to answer is, how important is insolvency law in the domain of law ID police? Is it really that core mandatory law? And then the question is, if it is, can you derogate? See, even the Ancetral model law on insolvency says that public policy exception is supreme. It also says if you have a bilateral treaty, that will prevail. I think it comes back to that same question of how strong a country believes that they need to govern the people within their jurisdiction, right? It is not that there are other areas of law where people have not done it. Even in competition law, for example, Indian courts will not allow arbitration, but the US will, right? Competition, if you think of it, is a public policy question at the end of the day. I mean, you can distinguish between in rem, in personam, and all of that. But at the end of the day, it's affecting the public at large. The question, I think, is, does arbitration make for more efficient insolvency proceedings? I think Chitra will point this out later, but even in an Indian IBC proceeding, how long are you struggling? Can arbitration then effectively address those questions? And if it can, then is that not a public policy ideal that a government should pursue? Because at the end of the day, there is no sense in restructuring my companies 8 years down the line, where you've practically taken me out of business, right? If arbitration can expedite that and turn around the company in 6 months, 8 months, or a year, why not? Is that not good enough public policy?
I have a slightly different view from Ajar's on this, which is that is timeline the only thing? Is timeline really the only thing that we're looking at when we're talking about, oh, insolvency versus arbitration? There are several attributes to arbitration, nuances to it. And do we actually want all of them seeping into restructuring of the company or insolvency resolution of the company? I think that's also another question. So for instance, I'll take a couple of examples. So for instance, arbitration is supposed to be, even if I consider that India signs up for some submission agreement where all parties automatically get signed up for insolvency resolution process through arbitration, I think the question still remains, arbitration is still a confidential process that is undergone. So what kind of law are you setting on very critical aspects of how stakeholder interests, multiple stakeholder interests, conflicting stakeholder interests have to be aligned? And will that lead to, if you do arbitration for insolvency resolution, will that lead to a disproportionate number of misaligned outcomes for various stakeholders? That's one point. The second point is that just by the very variety of stakeholders, you have creditors, you have employees, government authorities, tax authorities, all of those people who are claiming through them, vendors, sellers, people who are still continuing to perform contracts, everything, every part of the company has to be looked into. If you do insolvency resolution through arbitration, and let's say there is a position that comes up or an issue that comes up that has not previously been discussed, or a law on that has not been laid down. If you're before the courts and it becomes an issue which is publicly discussed and debated, we have seen in the past that the IBC has been amended to bring in requisite changes so that all stakeholders' interests can be addressed. Will that still be the case if we continue to do arbitration? That's another question that we have to look at, because otherwise what you're looking at, progression of law in a certain silo where stakeholder interests may not be effectively addressed by legislation. So that's a concern. And honestly, that's a concern we've even seen in some arbitrations. In fact, there is a dialogue on to what extent can arbitral awards be made public for certain relevant issues, which are, in fact, a lot of bigger companies are now going only into arbitration. So there are some issues that are not being brought before courts or cannot be disclosed, and we don't really know how to progress because, or subsequent litigants don't have an idea of what to do on those issues because there is no jurisprudence that's coming forth on these issues, including like foreign exchange, valuation of shares, etc. So we've seen a lot of those things. So it's not like that issue does not exist in arbitration. It does. But to my mind, it compounds itself manifold if you take up an entire company with its full bundle of business and liabilities, etc., and then say, hey, listen, we're going to do it behind closed doors. So that's my concern.
Right. Can I just quickly add to what she said? Again, this is not my personal view, but I'm just trying to be the devil's advocate at all points. You have the transparency rules. You have ICSID as an example. If you are looking at a bigger convention, the confidentiality exception can be taken out, right? Gary can correct me, but I think in Singapore, the court rules say that you cannot use the names of the parties when you file which is why they're called X versus Y or C versus D, as opposed to our courts where, well, arbitration is confidential, but everybody knows everything, right? In that sense, insolvency proceedings can also be made public if required. See, because when you're dealing with an aspect which is so new, you also have a clean slate, right? You don't have to confine yourselves to the so-called USPs of arbitration strictly. when you're looking at something which is entirely new. So just that, I mean, it's possible. I don't know if it'll succeed, but it's possible.
If I may, add, yes, we can think of arbitration differently. There's also the trend now to push for publication of awards, anonymized awards, which is another way of taking care of what is the common law problem of not having case law. Because in civil law, case law is not binding anyway, so it's not that much of a problem.
Any question, in the audience?
Hi, I'm Harsh. I'm a second year at NLS. I had a question mostly with regard to procedural aspects of how an arbitration with regard to insolvency could proceed. So imagine there's a company of creditors, and as you've all pointed out, there are multiple stakeholders. How do you ensure equality of the parties in the appointment of these arbitrators? There's also the question of, well, IBC is mandatory law, but Indian law does allow you to pick a foreign law as your governing law. So in that case, can a court strike down the arbitration if the parties have adopted a foreign law? Given the increasing complexity of how contracts are structured, I have a question of how much can you involve parties who have not necessarily signed the main agreement, but might have signed a sub-agreement or something like that. Does the arbitration clause in the main agreement still apply? So I just wanted some insight regarding how these procedural issues could be addressed. They're perhaps not as important as the broader sovereignty or public policy considerations. That's something else to discuss.
Yeah, so Indian lawyer, this is specifically on the IBC and
IBC
the
member.
arbitration.
See, I do agree with what you're saying, right? Which is, it seems to be a problem, right? How do you get all the creditors to agree to an arbitration? So that's what you're asking, right? How do you have them to agree to an arbitration clause? And I think I'm on the structure itself. I'm not able to understand how do you structure an arbitration agreement. An arbitration is focused on where one party will prevail over the other, right? But the way, and it may not be necessarily that it's majority, but it's somebody who's right on law. But the way a COC works is, it works on what is the larger benefit which will result in revival of the corporate debtor and in ensuring maximum realization from the assets of the corporate debtor for the creditor, right? An arbitration agreement is fundamentally different, right? And I'm just trying to structure it. I would guess how they do it with DTDs, right? In the beginning, when you have a creditor onboarded, you will have a standard agreement to say, if you have a dispute, you will agree to arbitrate it, which is fine. But how do you implement it? What are the terms? And I think we are, like Varuna said, we are far from devising that strategy of when we do enter into this arbitration agreement with prospective creditors, what will it look like? Will it look like a standard arbitration clause which says that we appoint an arbitrator and the arbitrator adjudicates on the dispute? But what's the dispute? You have 20, 30 creditors who keep changing over the course of the 10 years. When I signed the arbitration agreement, I didn't know there'll be 20 other creditors. And will it be the maximum interest that will prevail? Or will it be who's right on law? And if you go on who's right on law, then the debtor is not going to be resolved. Because at the end of the day, this value maximization, debtor resolution is not going to happen if one is going to stick to the concept that I was correct on law, right? So even I don't know how you're going to structure this kind of an arbitration agreement. The majority rule, which is in the IBC, seems to be working very well in value maximization for creditors and revival of the corporate debtor. So that's I'm more on the conservative side on this.
So I was wondering if I can wear Ajay's hat for a bit and be the devil's advocate, which is, so my thought process is this. See, if we are to be taking this stance that, oh, how do you protect everyone's interest and if an arbitration is going to go through, I think what we all realize as a panel or as a room now full of people who are thinking about it is that it is not going to be your standard insolvency process. It's also not going to be your standard arbitration process. The way I look at it, it will be some entirely new hybrid kind of mechanism that you're talking about. It will certainly not be within the confines of what we understand as arbitration and insolvency resolution. So for instance, if you're talking about, signing up for arbitration agreements, resolving smaller stakeholder disputes. So if you're going to have an overarching, let's say, statute or a global convention where people say, hey, listen, if an insolvency has to happen, then and it has to happen by arbitration, we will have X party appointed, or the corporate debtor with the 5 main creditors will appoint an arbitrator, but everyone else will have to gravitate towards that body. That's going to be a presumption. So an arbitration model for insolvency will come with a lot of ifs and buts and a lot of built-in regulations where it will not be fully autonomous, is the way I look at it, because you cannot possibly have that kind of an agreement or a mechanism. So it's really going to be that kind of very fluid thing that you're signing up for.
But I think, Paruna, I think where the questions I feel are coming from are that at the end of the day, then it's not arbitration. What you're doing is
Yeah,
you're taking the domestic legislation and you're just applying that at a international level.
Yeah.
But it's not arbitration. What you're saying is I'm going to have IBC, but an international convention of it.
The only characteristic of arbitration that's going to remain is that maybe someone will be able to hopefully choose their arbitrator. Apart from that,
But it would come to the same thing as, again, IBC, you have a resolution professional who does that role, right? The resolution professional gets all the creditors together, has the meeting and says, okay, now vote on the resolution plan. That's exactly what's going to happen. But it's not the role of an arbitrator. Arbitrator is one who will say, okay, this is your position, this is your position, I'll tell you who's right. But I think what we are then aiming towards is not an arbitration model, but what we are saying is we'll take the domestic model of IBC and apply it at an international level, which is slightly different.
yeah, I mean, it's all going to be very somewhere in between.
And then call it an award so that you can use the New York Convention. That's exactly what we're really trying to say.
Yes.
Right? That we'll somehow internationalize the role of the resolution professional. Take a side committee, say, I am now supreme, call it an award and have it enforced everywhere.
Yeah. Something like that.
And now just that plain simple statement can tell you why Gary said, I don't think it's happening.
But I mean, the question of the procedural point, these are kind of things that can be solved. We can think about ways of doing it. And maybe that goes to the question, what is the role of institutions it might be possible for an institution to try to figure out a way to attract this kinds of, if ever national courts agree to let that go. I think it's, again, I'm too old to expect to see that in my lifetime.
I would just say that, I mean, one thought, in the public law domain, we have nations nominating certain judges on the Permanent Court of Arbitration or the ICJ, for example. You could imagine certain countries on a sort of regional basis to be able to appoint certain judges on a rotating basis in a similar fashion. It's been done in other domains and it's not unimaginable in this particular domain.
I think one example that comes kind of close to this public policy question is the International Criminal Court, right? How do you, because see, criminal law is also something which is so sovereign that no country would give it up. But then you have an extraterritorial body trying to deal with that question, or the tribunals that happened for World War II. So it's been done before. It's not that it's not been done before. Has it been successful or not is a separate question. But if you would really come down to it, you can think of, but I agree with what she said, it's not going to be arbitration or insolvency. It's going to be a creature of its own, right? And I think there's something called Arb-Insol, something to that effect.
If I may break away from this topic and go a little bit back into the introductory remarks where you were speaking of the arbitrability itself of these issues. Could I have the panel reflect on the need for the distinction that has been created between core and non-core, ancillary and non-ancillary issues, especially because it's likely that many of the issues that might arise in these insolvency-related arbitration matters may actually overlap. So you may not necessarily, they may end up being mixed issues. So is it a more superfluous distinction that's being created? Or is there a more watertight way to create a distinction such that it can be applied perhaps internationally? Because we see there's a difference in the way in which Indian courts across the world are dealing with these core and non-core issues and their characterization of this.
Okay, I'll go first. So, well, I think that I spoke about this a little bit. Yes, in the US, we have the discussion on core and non-core issues. In India, we itself have, I think we do have that distinction without sort of stating it, which I was talking about financial institutions, right? We barely have financial institutions that are subject to insolvency. Now we have non-banking housing financial companies which are subject to insolvencies, but there's a separate regulation for it. So I would think that insolvency of financial institutions across borders is definitely going to be a core issue, which is not going to be subject to arbitration for sure, right? The other, which is more standard, and I'm sure Gary and you can comment on this, is avoidance applications, right? Those are issues. So one of the reasons you have insolvencies, you are also an avoidance applications, is you're recognizing that the management of the corporate debtor was fundamentally involved in the downfall of the corporate debtor. Hence, you want to overturn transactions that would have happened probably 2 years back, 3 years back, 10 years back, right? Usually, nations don't want to give an outsider the power to have control over what kind of transactions they will be allowed to be overturned. This should be decided by a judicial organization within the nation. So, avoidance applications, mostly across board, are treated as core issues which cannot be arbitrated. Gary, you could.
Well,
I'm sure you had.
there are differences in different jurisdictions. The main idea of having a distinction is there in most, but the exact distinction is a bit different. What I would say is that one of the main issues in looking at this is, sorry to put it so bluntly, but who do you favor, right? Because if you favor the creditor, you decide what is the core and non-core in a certain way, and exact contrary if you decide to favor the other side. So the process of bankruptcy has moved from favoring the creditors in many jurisdictions, moved to restructuring, which is giving more protection to the debtor in many ways. So what you define as core, how much you want to give, for example, as was mentioned earlier, if that might bring more money to the debtor, will allow the arbitration to go on. But if it's going to create a new debt, we won't allow it, right? So this is obviously a definition of core and non-core that favors the creditor, right? Is that the right definition? Now, if you are thinking in terms of protecting the debtor, you might look at it differently by saying, well, we need to know what's the answer to that. If that is in favor of the debtor, that might be thing. And so I think that even the core and non-core is not that neutral in any case, right?
But I think the core and non-core is actually, if you really water down all the legal jargon around it, what are we simply saying? I think it was a point I mentioned earlier. Is the insolvency being invoked on the basis of a disputed debt? And that disputed debt is subject to an arbitration agreement. Then we decide whether that affects our public policy or it doesn't affect our public policy. But if the question is that the debt being, why the insolvency court is taking cognizance, has got nothing to do with arbitration, then I think there is no question of core or not. The only point at which that analysis is even required is if there is a competing arbitration agreement to determine if this insolvency proceeding should even be invoked. Otherwise, that distinction is, to my mind at least, not required.
Okay, so let me bring another important issue, which I believe is important in this context. If at all the jurisdictions allow these otherwise parallel regimes to come together and overlap, or if even in the other case, if they would allow the overlap or the interface between and they only allow the parallel proceedings to happen. So do you think a problem of forum shopping happening in this context where the parties can pick one advantageous forum for their case, and what are the possible consequences if you can think of in the context of forum shopping?
I mean, I think that's one of the bigger problems in cross-border insolvency through arbitration is that ultimately it becomes a fight of the right forum, right? It's a forum selection conflict that happens. Are you saying that people use insolvency as guerrilla tactics? Well, they do. I mean, it's the unwritten thing that if I know that she has a legitimate arbitration claim against me, I will get her to file an insolvency against me so that I can defeat her arbitration agreement. Right? And I know of many matters where clients have done it deliberately so as to defeat the arbitration. So if you're saying that it's not being done, obviously it's being done. Can you stop it? That's the question. And that can only be stopped if you have some other means of preventing it, which is binding. As long as you continue trailing in these two parallel boats of arbitration and insolvency, what is going to happen is, I think Singapore 5 days or a week ago held the Philippine company to be in contempt when it had issued an anti-suit injunction. So ultimately that sovereignty is going to become ego. And then ego is going to become contempt. So do you want to risk it? That's a judgment call, then the lawyers and the clients have to make.
But I think like if anyways I think it's very evident that I'm against the whole concept of having an international framework. But if there is one, I would assume that it would try to protect that interest, right? If for example, a corporate debtor has assets in 20 places, but in one place it's only for maybe 1 million and other places for 500 million, it'll make sure that it protects and doesn't let people to sort of, bring up unnecessary arbitrations in a place where there isn't enough assets, but just because it's more of a convenient. But I think that's more about the drafting to protect the interests of all parties and make it more collaborative and equal for participants.
I think because she's on my side for once, I'm just going to say you can take examples from the Rome Convention or the Hague Convention or other conventions where you can naturally gravitate to a particular jurisdiction, ousting the others. So in that sense, then the court looking at it would, or the tribunal looking at it would then determine this question of whether the proceedings have been brought in bad faith. That's the only way you can kind of resolve it.
Talking of international conventions, so let's come back to the international legal framework. So in the earlier remarks, I think almost all the panelists mentioned about the model law on drug insolvency, and also particularly on the success of New York Convention and how both these international model law and the New York Convention is going to impact this overlap between insolvency and so do you think is it the reach and the success of the New York Convention particularly is it going to make jurisdiction to countries to or international community to come to a collaborative idea of making insolvency disputes out?
Yeah, I'll just touch on a few points. So I think many of you are aware of the provisions of New York Convention that would have relevance to this issue. I think the most important that's been mentioned is the recognition of the arbitration agreement is critical under the New York Convention, but also New York Convention recognizes the interim measures that sometimes there is a need for example, freezing orders that may be required, and so New York Convention does recognize that. But this again, this is on one side, and then the model law, as Gary was mentioning, it really has another function, which is to try to bring together parties in a more collaborative way. I think some of the principles of that convention. So now I understand 60 countries have signed on to this insolvency model law. So it's not not like New York Convention, which is 69 or so. So it doesn't have the same number in terms of the participation. But the purpose of this UNCITRAL model law insolvency is really to, giving access to the various creditors in a common forum. The other principle is recognizing the foreign insolvency proceedings and granting relief. So the recognition of whatever decision is made. And then the third principle is the cooperating and coordination. So there are suggestions about information disclosure and document production and recommendations on how those processes should be conducted in a sort of joint manner. So again, this I think it's already been raised, but this will potentially could raise, under the New York Convention, there are challenges that can be brought. So the challenges, of course, we know, jurisdictional issues. So whether the insolvency from different the creditors from various jurisdictions, whether this is the appropriate form or the appropriate jurisdiction to hear the claim. And the second, which I think has already been mentioned under the New York Convention of the Public Policy considerations, so if it is found that this insolvency is the core and it's precluded by national law on public policy grounds, then you have issues about challenging the award under the New York Convention. So you see that now the current regime or global regime is not consistent or congruent. And so there are mechanisms within both to kind of undermine the functioning of the other. And so I think until there is sort of a uniform system, as was mentioned, perhaps outside of arbitration, these kind of countervailing pressures will continue to exist, both under the New York Convention and this UNCITRAL regime.
Just to put it more pessimistically, we are signatory to the New York Convention, but we've all had fun enforcing awards, right? The question is simply signing a convention enough? If your courts will continue to still be who they are and not recognize it, not recognize the pro-arbitration or pro-enforcement aspect. And I mean, you've seen the Supreme Court decision change the award because they thought it fit and really undo everything in arbitration. But if that's the case, then even if we have 170 odd signatories to the insolvency model law, what has really changed? Unless your courts are actually willing to give deference to it.
Then the call is again for the international community to come up with some judicial roadshow to teach the judges, like we did in the case of New York Convention, teach the insolvency adjudicators. Sana, do you want to?
No, I
Okay. I think we already reached, we closed the 16 minutes or 1 hour mark. So at this stage, may I ask if there are any questions or comments from the audience on any of the topics that we discussed so far? Topics and subtopics.
We have one question.
Yes, please.
I'm sorry, but something that one said that piqued my curiosity, just in terms of preventing the dissipation of assets, which a lot of companies would do when they fear they're reaching insolvency. Is arbitration even the best forum to prevent that from happening, to get interim measures? Because I would imagine courts are a far better way because they can actually enforce their orders. They can, there are far more powers with regard to the assets the companies possess, be it the insolvency court or other courts. So in terms of interim measures, ex parte, not ex parte, would arbitration be a good enough forum to do that? Would it be faster? Is it more appropriate? Can you even enforce it? Just in terms of that.
Well, in arbitration, you can go to the courts as well to get interim measures. So it's not, it doesn't exclude that recourse. I should say that the 2006 version of the model law on arbitration has a whole chapter on interim measures, and it's well written. It's interesting. The problem is how do you get that recognized outside of the jurisdiction in question? And this is not many countries have accepted that interim measures. So, but you still have in arbitration recourse to the courts for interim measures. So, but it is a difficult thing because if assets are in one place, not so bad. But if assets are all over the world, it becomes very costly to get all of this.
So also,
Yeah, go ahead.
sorry, I was saying that I think the question is also about if insolvency becomes imminent, then what really happens to how do you protect assets, how do you protect your interests, etc. See, the thing is that if insolvency becomes imminent, at least as per the existing Indian regime, there's not much of a recourse that you have. Even if you go get a Section 9, does not matter. Your insolvency will put a moratorium on everything. But what we do, and that's actually outside of the legal realm, is for parties to be vigilant about how your corporate debtor or your counterparty is doing financially and otherwise. Sometimes when we anticipate that a party may be filing for insolvency or basically is at the edge of the seat on that front, we try and figure out how much assets do they have, what do we need to do. Then if say you're a financial creditor, you may want look for opportunities to accelerate the debt so that your claim is crystallized and you can try and get that claim money out before the insolvency starts. So it's really going to be a lot of practical tactics that you have to employ to protect your interests. It's not necessarily just going to be court processes or a Section 9 or a Section 10.
Yeah. There was a case that I helped to arbitrate between a Los Angeles merchant in seafood and a China seller. And in their particular case, this was during COVID, the China seller collateralized their home. They said, you take our house as a collateral. You know, they knew that they were extending themselves and they weren't sure whether things would turn out all right. And so they put their private assets on as collateral. And in the end, that was what was sought for the resolution of the sale agreement. It was under CISG, but it was very creative, as you said. And parties may have to think about this and think about how they're actually going to, if they are going to take risks in long-term relationship, how they're going to manage that with various other mechanisms outside of the normal mechanisms.
I haven't done that yet, so I have to do a little bit publicity for Singapore on one tiny point. Your question about interim measures. Singapore has, I don't think it's going to solve anyone's problem, but it has taken very strict changes to interim measures. In Singapore, the courts cannot grant interim measures if the tribunal in Singapore is constituted. But the interim measures by the tribunal will almost automatically become a decision of the court to recognize. The other thing that Singapore has done is that it has extended the recognition of foreign awards to foreign interim measures. So if you get an interim measure from another country, from a tribunal that's seated outside of Singapore, you can get it recognized automatically as if it was an award. I think there are lots of problems with that. It's not a very good way of doing it. 2006 anti-trial version would have been better, but you can see that they're trying to give powers to arbitral tribunals.
But the question you've asked is, so my doctoral thesis was interim measures. So I can go on and on and on about telling you how it can be done. But the bottom line is, if there is no arbitration agreement and you want to go and save an asset, let's say in Singapore, the arbitration is between an Indian party and a French party. The only asset is in Singapore. In the absence of an arbitration agreement, how will you do it in Singapore? The benefit of the arbitration agreement is that you get the benefit of extraterritoriality, right? You get, let's say arbitration is seated in Dubai, but because of the extraterritorial application, even under the Singapore International Arbitration Act, the remedy would be far quicker. Because what otherwise would happen is you would have to first satisfy jurisdiction in Singapore court. You have no in-personal jurisdiction. The Singapore court has no in-personal jurisdiction over you. How are you coming into a foreign territory, praying for a relief? That is the benefit of arbitration. And when we say delocalize things, that's what we really mean. That arbitration and the seat creates these fictions, which otherwise you don't have to deal with questions of jurisdiction, right? And that's why it would be far quicker to get that asset secured than without arbitration.
Any more questions?
Assume that everybody's asked their questions based on their moot court problem.
Right. If there are any,
So we can answer that question if you want.
Yeah, I think all of them are going to be judged. Hands down. All right. So if there are no more questions for the panel, let me thank all my excellent panelists for their excellent contributions, Gary, Shala, Ajay, Varma, and Chitra, and also my colleague and co-moderator, Sahana, for this interesting conversation. Anirudh?
As we approach the conclusion of our conference, I would like to once again extend my heartfelt thank you to all the distinguished panelists as well as the participants for your interest and patience. I hope this conference was enriching and left you with several thought-provoking questions as well as insights to mull over. May the discussions here today serve as catalysts for positive change and innovation in the study and practice of arbitration law. And once again, I'd like to thank our panelists, Professor Shala Ali, Mr. Gary Bell, Mr. Ajar, Ms. Varuna, as well as Ms. Chitra. Thank you for your interest and patience, participants, and may the rest of the competition be rewarding. Thank you.